In this week's episode of the Crushing Debt podcast, I talk about foreclosure sales and surplus balances.
Welcome to the Crushing Debt podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt podcast. My name is Sean Yesner, and like I said in the introduction, I have a listener question for you this week about surplus funds following a foreclosure sale. But before I get there, a couple weeks ago, I mentioned in a podcast episode that you all should check out the Swipe the Podcast show by our friend Polly B. And while mostly our episodes here have been sponsored by Yesner Law, the podcast here is designed to support the law firm, I am very pleased to announce that we've picked up a new sponsor in Polly Bauer and Associates and Swipe the Podcast. So I really would recommend that you go check out Swipe the Podcast with Polly B. But for Polly Bauer and Associates, they specialize in teaching you how to grow your business through the right payment methods, providing e-commerce education and expansion strategies, and educating you on the value of early detection and prevention of fraud. You can learn more at their website, www.pollybauer.com. And as always, make sure you check out her new podcast, Swipe the Podcast with Polly B. So I am pleased to announce that we do have now a sponsor helping out with the show, and we are now also a sponsor of the Swipe the Podcast show as well. So both podcasts seem to be very symbiotic, and it's a relationship that we are very, very much looking forward to continuing as both podcasts and both companies continue to grow. But today, like I said, I've got a listener question for you. So I had a listener reach out and ask me the following question. At a foreclosure sale, the winning bid is often well above the bank's threshold, well above the threshold of the first mortgage. The residual balance generally goes to junior liens if they file, and if not, the balance to the prior delinquent mortgagee, the prior delinquent borrower. Can this remainder balance, the surplus balance, be claimed by a new owner to satisfy the association back dues, even if the association has not filed a lien? In such case, should the new owner file immediately to stay the excess funds disbursement from the court registry to the prior delinquent owner? I think that's a fantastic question, although there are a bunch of subparts. So let me see if I can deconstruct it and reconstruct it for you here in my answer. So I think the first point is that now we are starting to see foreclosure sales above the amount of the mortgage, above the amount of the judgment, creating a surplus. Now, if it's the other way, if let's say you have a judgment of $100,000 and the property's only worth, let's say, $65,000, well, now you've got a $35,000 deficit. But in this question, we're assuming that you have a judgment of $100,000 and maybe the winning bid was $140,000. And so now you have a $40,000 surplus. So that $40,000 surplus generally goes to the junior lien holders if they file a claim. Now, under Florida law, they have 60 days to file a claim to request their surplus. And then the court has a determination as to which junior lien holders, which junior liens have priority. So does the second mortgage get money before the association gets money? Does the association get money before a judgment creditor gets money? What about different issues that affect the property, like code enforcement liens and those types of things? What is their priority in terms of when do they get paid based on if there's any surplus? But in this question, let's assume that there is no one entitled to surplus other than maybe the former property owner, or maybe we assume that the junior lien holders don't file a claim. So I think this particular question, or the particular circumstance that created this question, was a homeowners association that allowed the bank to foreclose, didn't try to collect for months, for years. And then after the foreclosure sale, they went to the new owner of the property, the person that bid on it and won it at the foreclosure sale, and they said, we want all of our surplus, all of the money. The association approached the homeowner and said, we want all of our back dues. Now, at this point, the winning bidder said, well, wait a minute, there's, however much money left in the court registry. In my example, $40,000 left in the court registry. Association, why don't you go after that? And the association said, well, we don't want to. You are liable for that money, so we're going to go after you for it. And so the winning bidder now is asking, can the winning bidder go back and get the surplus proceeds from the court before the homeowner does? And I'm actually going to come out on the side of saying, yes, I think that the homeowner association owner, the new owner of this property within the homeowners association, can do that. And Florida law says that the unit owner is jointly and severally liable with the previous unit owner for the amount of those assessments. So I think the way that I would approach this, if I were the new owner of a foreclosure piece of property, is to file a motion with file a motion with the court and say, Judge, I am jointly and severally liable with the person who just lost this property. There is a surplus of X amount of dollars in the court registry. The homeowners association, instead of filing a claim in the surplus situation, has come back on me and is trying to collect from me. Well, since I am jointly and severally liable with the previous homeowner, and the previous homeowner would be entitled to this surplus being held in the court registry, Judge, please allow me to withdraw the money that I need, the money that I've paid in to buy this property, from the registry of the court, and use that money to pay the association instead of giving that money to the homeowner. In other words, we don't want the homeowner in this situation to get a windfall simply because the association is lazy. Now, I don't know if that legal theory has ever been tested. I know that I certainly have never made that argument before in a court of law, but it certainly is a very interesting angle on the question. So what I want to know is, what do you guys think? I know I've got a lot of listeners who are real estate investors, and so you all bid at foreclosure sales all the time. Do you think that in a situation where there are surplus proceeds sitting in the court registry, and there is also money owed to the association, but the association refuses to file a claim to collect those surplus funds, could the new owner of the property, who otherwise would not be entitled to that money, make a claim and make the argument that the new owner is jointly and severally liable with the previous owner, and rather than the previous owner getting a windfall and walking away, the new owner wants the previous owner to use some of that money to pay the association that the previous owner, up until that point, had not been paying? I think it's an interesting legal issue, and I think maybe it's one that I would like to test at some point, and so we'll see if the right case with the right fact pattern comes along. And certainly if you're listening and you have this fact pattern and you live in Florida, give me a call and let's kick it around and let's talk about it. So I think that's all for this week's episode, a pretty short episode here, but I do thank all of you for listening. Again, if you live in an association, or if you buy a piece of property in an association at a foreclosure sale and there is a surplus of funds left for the association, but the association has not filed a claim and is asking you for money, give me a call. Let's see if we can negotiate something with the association to make them go away. So that's all for this week's episode of the Crushing Debt Podcast, and I look forward to speaking to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.